Okay, welcome to this session of the Sixth District Court of Appeal. My name is Judge Joshua Mai, sitting to my right, Judge Pedro Brownlee. We also have with us Judge Denise Beamer of the Ninth Judicial Circuit. We're very grateful to the Florida Supreme Court for allowing her to sit with us today. The first case on the docket is 23-3104 Arlene Oliver versus Wawa Inc. I'll remind everyone that the proceedings are being live streamed on YouTube, and the appellant may approach.
Thank you.
Mr. Shanine, how much time would you like for rebuttal?
5 minutes for rebuttal, please.
Okay. Begin, counsel.
Good afternoon. May it please the court. Not often that I get to give a good afternoon to the appellate court. I'm glad to get a chance to do so. My name is Nick Shanine, and I represent Miss Arlene Oliver in this important case regarding the standards for which a trip and fall case are to be decided in the state of Florida. Miss Arlene Oliver was walking in the regular course of the concourse from the gas pumps toward the station's main building at a Wawa when she slipped and fell in a oatmeal-like substance. We do not know who dropped the oatmeal-like substance, and frankly, it does not matter. What did matter is the fact that that oatmeal-like substance, A, was there. She tripped in it, and the employee from Wawa came, saw it, and cleaned it up after she fell. B, that we know that that substance was on the ground for at least 19.
How do we know that?
Well, we don't have a crystal ball to know everything, but what we do know is that there is surveillance video showing the front of the Wawa store. We see the spot where she tripped. We see for 20 minutes preceding that until the video starts that no one drops a bowl there.
Does the video give you a clear view of every person that could have dropped it there?
It actually does give I'm impressed by the surveillance video. Normally,
what about the cars, counsel?
A car passes through the screen. It is possible that some mischievous imp ran out while a car was coming, dumped a bowl, and then ran behind the car, so we never saw the person.
No, counsel, what about somebody throwing something out their window?
While that would be possible, it's unlikely, but I'll give this to where the court is leading. That currently there are no inferences at all necessary to prove Miss Arlene Oliver's case. If this court were inclined to believe that that possible hypothetical would be enough that it could draw and require an inference,
Isn't it just
that's
as likely though that happened as the idea that it was there before the video begins? So presumably, if I saw lots of cars going by,
Sure.
I saw a couple people, one of whom goes right through the same spot that your client walks through and doesn't look down, doesn't seem to notice anything at all.
Sure.
And then I think right after that, a car goes by. Isn't it perfectly possible for someone in the backseat passenger side to have just tossed something out the window real fast? And then that's the reason the other gentleman walked through just fine?
The reason why that appears to be honest, a stretch is that, first of all, it would have to be specifically from only the side of the vehicle we cannot see. And it would have to have been so quick that we don't see anything before and we see it afterwards. And the video appears undisturbed in its appearance from 00.00 through to 19.54 when the plaintiff falls. What I'm suggesting to the court is that we can take any instance. If this direct video surveillance is not enough to satisfy the test, then there is simply no way a plaintiff can prove a case.
And you make a lot of the brief of calling the video direct evidence, but for me, for the video to be direct evidence, we would have to have a clear line of sight, nothing obstructing our view of that spot the whole time. Because the argument you just made sounds a lot like an argument you would make to a jury about why they should infer that it was there the whole time.
And Your Honor, not to interrupt, but I'm willing to agree that it could require an inference. And if so, that is the inference.
Right.
She is allowed one. And that is the one that she would cash in order to allow the jury to do its job.
So it's not the first inference that if the video doesn't show anyone dropping the oatmeal, then no one dropped it. That's one inference, right? And then the second inference is if no one dropped it, then it was dropped more than 20 minutes before the plaintiff slipped.
In other words, you're allowed one inference per line of you don't have to do one on every branch that one can imagine. But given what this court has just hypothesized, then the answer is yes, that we need either the inference in this court's analysis of the video for if we agree that at 20 minutes, we see no defect, no substance, oatmeal-like substance in the frame of the camera. And that during the course of it, that there's either inference A, that no one ever does drop oatmeal, or inference B, that someone does do this
Hold on,
thing.
those are alternative inferences.
Right, alternative
And
inferences,
so what
correct.
we're talking about is once you've selected one out of the
Right.
two alternatives,
Correct, Your Honor.
do you have to stack something on top?
And,
Right,
and
you have
we-
to go from inference to inference. So if your first inference is no one dropped the oatmeal,
right,
right, that's
that
inference
is,
number
that is our
one.
primary inference, yes, Your
The
Honor.
second inference, I assume the other side, and it seems like the trial judge concluded would argue is, therefore, the oatmeal was there at the start of the video.
Correct.
Is that
Your
not
Honor.
a second inference that is based on the first inference? No one dropped it, inference
Right.
number one.
Right.
Inference number two, therefore, it was there before the video started.
I would urge that that is all one linear line of thought, that it doesn't require two inferences for that. That, in other words, because we know these things to be true. We know there was an oatmeal-like substance where the plaintiff fell. How do we know that? We not only have her testimony, but we have the witness testimony of the Wawa's employee who says, yeah, I had to clean something up that was right there. So we do know that it existed. That's a fixed point in fact. We also know that 20 minutes beforehand, this video started and showed the scene that we now see. Therefore, one of two things is true. That oatmeal was there from the beginning of the video and before, or it was not.
It sounds like you're saying you don't think it's two inferences, you think it's one inference
Yes.
and a logical conclusion to be drawn from that. inference.
That could, thank you for stating it, because that is exactly what I was attempting to communicate.
But even assuming,
Go ahead, Judge Beamer.
Oh, but even if assuming that the oatmeal was there are no plus factors that the case law kind of talks about, and just the mere presence of a substance is an
Sure.
evidence.
Allow me to answer that with two things. First, in the construct of what a plus factor would be, I would ask this court to apply the supremacy of the text principle. We are bound to follow the legislature's guidance, and the legislature has given us explicit direction as to what the duties are of the landowner and the proof requirements of the person who is attempting to sue that landowner. And that test, of course, is that first, and this is statute 768.0755 subsection 1, where it requires for a person who slips and falls on a transitory foreign substance, precisely the scenario we have here, to sue a business establishment, the injured person must prove the business establishment had actual or constructive knowledge. They give the either or. Actual is great. If we can prove they absolutely knew that substance, they tried to clean it up, they
I think
didn't.
what you're trying to say is the statute doesn't mention plus factors.
That is exactly where I'm
Does it
getting
mention a
to.
15-minute rule?
And nor does it mention that that's also a creature of judicial creation.
Okay, so you admit that's completely made up. The other DCA's just made up that rule.
I do. I would say this.
Is there a reason neither side brought that up?
Well,
We're arguing over whether a rule applies and nobody mentioned that the rule was completely conjured out of thin air by our sister courts.
I would urge this. First, that 15 minutes to my mind sounds too long, but we can live with it in this case
Does it
for
sound
obvious
too long
reasons.
for the outdoors? So when I look at the language of that statute,
Right.
okay, it says for such a length of time that in the exercise of ordinary care, the business establishment should have known of the condition, which seems to me to create a fact issue as to the, what would happen in the exercise of ordinary care.
Sure.
In a lot of contexts, I think of standard of care as requiring expert testimony or some type of evidence as to what the standard of care would be.
Sure.
So instead of, if I'm looking at the text of the statute, as you pointed me to,
Right.
I'm ignoring the 15-minute rule since that was made up. And I'm saying what evidence was there of the standard of care?
Sure.
Okay. I
Well,
didn't see any put in, and
I-
maybe that's because everyone was relying on.
I
DCA
would
case law for
answer
15
this
minutes.
to the court two
Let me
ways.
give you one more point before we do that.
Sure thing.
If we were going to have a 15-minute
Right.
rule, it seems to me that you could kind of see the logical reason for that indoors, right? There's employees walking around. That's
Right.
where they do their primary job. Everybody's there. And it would make sense that you'd expect employees to see something that it's been there a sufficient amount of time. I couldn't find any case, and if there is one, please point it out to me, where any court applied the 15-minute rules to an outdoor area of a business. So to me, in order to say that, 15 minutes was long enough to create a issue of fact, you would have to say that at least the standard of care could include that employees need to inspect every part of the outdoor of a business where they don't normally work every 15 minutes.
So if I may, Your Honor, I would answer your question with this. First, the absolute agreement that the 15-minute rule, much like the plus rule, is not within the statute, and it is a creature of judicial creation. I believe that the 15-minute rule is an attempt to create a bright line because of the difficulty of weighing in where really the jurors ought to be the ones making this decision. But in this case, Your Honor, I would give the court this, that it should depend on circumstances, that if this were a trail in the woods, obviously it could be there for an hour. And it might still be entirely unreasonable to think a forest ranger is going to walk by in that period of time. But here, where you have a busy car park, where the 4 gas stations right there in the front entrance right here, and pedestrians are coming to and fro from those gas stations, there's a reason why Wawa had its surveillance camera right there, because of the amount of traffic coming in and out right there. These customers are people who are purchasing liquids from inside the store, purchasing foodstuffs from inside the store. They are coming to the store from gas pumps. The chance of transitory substances being exactly where this transitory substance was is high. And I would argue that a convenience store absolutely, positively should consider that area not to be outside, but
I think
instead.
you would need some kind of fact evidence as to what is the exercise of the standard of ordinary care in operating a convenience store and inspecting the outside. Because I'll just tell you, I can't imagine running a gas station that I would send employees out to inspect every part of the outside every 15 minutes. Now, maybe you could. And that to me kind of speaks to why it's a factual issue.
Well, and Your Honor just ended exactly where I was going to go, that it is a factual issue. And the interesting thing is, this is part of the reason why there isn't traditionally expert testimony on slip and falls of this nature, is because it is within the ordinary and customary knowledge of people, because we are the ones who traverse these parking lots. We know what's reasonable and what's not. And we, the people who would make up that jury that should have gotten a chance to answer this question.
But all of that presupposes that the oatmeal is there before the video begins to pick up. So I
That's
understand
correct.
your argument that the plus facts aren't in the statute, right?
Sure.
So we see them in the
And
case
I would
law.
like
One
to get
moment,
back to
counsel.
that after. But
One moment,
yes.
counsel. So, but if you had that, presumably you would she could come through and say, I think it was oatmeal, looked like oatmeal. The outside, the oatmeal was dried. Now that looks like the guy, that walks through a couple minutes before she does. And then the car goes subsequently. Now it looks more unlikely that he threw it out the window, because there's some dried, crusty stuff on the side. It had been there for a little while. It strikes me that there doesn't seem to be any evidence. And I guess the second part of my question is the idea that the oatmeal was there prior to the video commencing
Yes, sure.
based on nothing more than speculation? And if it is speculation, is that enough? And I'm asking you because it's your client's burden of proof and we're under the new standard.
Sure.
So that element has to be satisfied by the plaintiff.
Yes, Your Honor. And we agree that the burden does rest with the plaintiff. That burden should not be an unreasonable burden or an artificial burden, but the burden does in fact rest with the plaintiff. And that burden is to demonstrate that the thing that she stepped on meets this statute, which allows for actual or constructive notice, and plaintiffs have to prove constructive notice by inference. There's simply no other way to do so unless.
That inference itself is the idea that it being there for a sufficient amount of time gives rise to constructive notice. Is that an inference or a legal conclusion? Because what happens if it's an inference?
It is an inference, but it's part of that same train, such that you can't call it two inferences when the inference that the oatmeal was there is the inference, or you have your two tracks of the alternate inferences that we're going to treat. Either the oatmeal was there already at the beginning of this video, which we posit is the great likelihood of truth, that it would take the incident just like you described, the flyby oatmealing and gone, and yet we never see the splatter or anything like that within the context of the video. I pose to you it's highly unlikely, but given that that is a possibility, we now have to look at two tracks. We look at track one, where it's agreed. We see 20 minutes of direct evidence video showing no new anything. Therefore, that oatmeal was there. That's because the oatmeal was there at the end and it doesn't spontaneously exist.
So counsel, I think your question is that's inference one.
Mhm.
Is inference two not then? Therefore, I infer constructive notice.
Okay, thank you, Your Honor. And the answer is no, that would be simply a statutory conclusion that is. And that is perhaps to where this court gets to is 20 minutes sufficient by which we can logically conclude, legally conclude that the foreign substance does amount to constructive notice. And the answer we would pose is yes, not just because it exceeds the hypothetical 15-minute, but because under the circumstances of this case, it's an abundantly reasonable amount of time by which constructive notice should reasonably be allowed to be drawn. And a jury can reject that. A jury can go, nope, that was
But if we
20
were to-
minutes is not enough for us.
This way for us to write that opinion to say, in this case where we have no evidence of when it was on the ground,
Other
right?
than we believe at least 20 minutes before, but
We believe that. Okay, so let's just take that to its logical conclusion. If that's what we have,
Right.
then is there a way for us to write an opinion in a way that would not tell everyone, like Judge Mize just said, now you have to have a service team member walking around your gas station every 15 to 20 minutes. And that's basically the law of the land, because if you're in the 6 and somebody falls, you're done for.
I'm going to posit this. If you are a wise gas station retailer, especially a chain, at 15 minutes would be a reasonable amount of time to have one of your employees just do the circuit where you just go outside.
Wawa
look,
has a
and
lot of
see,
employees. What about the gas stations that just have the one?
you know, and
So now is every gas, or are we creating a rule that every gas station better have 2 people on duty at all times?
But-
One to man the register and one to
and
inspect everybody
the
outside
same,
every 15
the
minutes?
same is true for every restaurant, every business, that every business has these same
No,
problems.
but hold on. It's not true because
Right.
no case has applied the 15-minute rule outdoors. We'd be the first.
Well, and again, Your Honor, I would posit this shouldn't be deemed outdoors either. It is in the immediate carcass of the building. It's on the.
Was it
curtilage.
under a roof or was there no
Oh,
roof above it?
There are shade components to the gas station areas. There is not a tunnel by which she was walking under, but
Was she
you're,
exposed to the sky when she fell, counsel?
I'm
I
going,
watched the video. She was exposed to the
I'm
sky.
going to give you a yes, but I would also urge that we not create a new rule for outdoors that would actually include the very area immediately outside of the entrance where ingress and egress is not only expected, but necessary.
Did Wawa agree below that 15 minutes was an appropriate
That-
time frame to create a genuine issue?
That was part of the argument. It is that, well, we even, you know, assuming that 50 minutes is, then they argued other things. So yes, that's our argument that they did.
Hold
But
on, well, I was saying,
Yeah.
if you're saying assuming this is not the same as agreeing with it.
Right.
Is there somewhere in the record where they stipulated or conceded that 15 minutes or 19 minutes and 54 seconds would be enough to create a genuine issue? Like, was that legal standard agreed to below?
I'm not going to hold them to, there wasn't a signed stipulation that went to the judge. I believe during the back and forth in the colloquy before the court, I believe that was the suggestion even from Wawa's counsel that, okay, if that, then this, that was the then this, but I don't mean to hold them to that. In fact, I see that my rebuttal time is drawing near, and I would like to give them the chance to talk and then me rebut. So thank you, Your Honors.
Thank you, counsel. All right, counsel, whenever you're ready.
Yes. Good afternoon. May it please the court, Lara Edelstein on behalf of the Appali Wawa Inc. We're asking the court to affirm the summary judgment here in Wawa's favor because the plaintiff, as your honors have pointed out, did not prove that Wawa had constructive knowledge of the substance on the ground before her
So
fall.
can you tell me what the 2 inferences are? No one ever, it seems to me, the trial judge doesn't expressly state it in the order. I can't quite make it out in the brief. I understand exactly what your argument is, but are you able to identify the 2 inferences that would need to be stacked in this case?
As your honor indicated, the trial court did not specifically state what the inferences were, but I believe it was the fact that that the oatmeal was on the ground prior to the video starting. And then the fact that, I don't know what the court was thinking, but I know that,
Counsel, can you give us 2 inferences that would need to be stacked? If we're in a de novo posture, what are the 2 inferences that must be stacked, one on top of the other, in order for your client to win?
well, I'm not trying to avoid your question, but I don't think that the inferences here are necessarily relevant because the plaintiff didn't come forth with specific evidence to defeat the summary judgment. The only thing that the plaintiff came forth with was the length of time of the video.
But isn't it undisputed that the oatmeal existed? I mean, is that, I didn't think that that was a disputed fact. I mean, the record evidence shows that the employee came with a dustpan and mopped up some liquid with paper towels. And the plaintiff testified in her deposition that she slipped on something like oatmeal. So it existed at that time. I mean, it seems like this whole case is about inferences and stacking of inferences.
Yeah.
And even counsel in the lower court presented those two cases, and those cases are just told for, that summary judgment can't be granted when we're stacking inferences.
That's correct, Your Honor. There is no dispute that there was a substance on the ground. So that's not an issue and that's not an inference.
For you to say there's no specific evidence, there's a video, they're allowed to point to the evidence they're opposing summary judgment, right? So one of the things they're allowed to do is point to the evidence that you put in front of the court and say, Judge, we think this evidence does create an issue. So there was definitely specific evidence. There's a video. Now, whether that's direct or circumstantial, I guess kind of depends on what you think the video shows. But there was evidence. We have a video. So the question is, what does that video tell us? What could a jury properly infer, right? And does it create an issue of fact? So if the jury can reach one inference based on that video, then they're allowed to show the video to the jury and say, here's the inference, rule in our favor. If it takes two inferences, they're not. So can you give us two inferences that must be stacked in order for them to prove their case?
Well, I don't know that there are two inferences here.
Okay, so the trial judge was wrong then.
I don't think that the trial judge was wrong because basically the trial judge viewed the video. And as Your Honor pointed out, the video shows multiple pedestrians walking through the area, multiple vehicles driving through the area without any incident. Hold
on, counsel. The trial judge said this would require stacking of inferences for the plaintiff to win. Therefore, there's summary judgment. The order says that, right?
It does say that after it goes through all of these facts.
Okay, so at least that part of the order, judge said more than one inference. And you just told me you're not sure there's more than one inference. And it seems like at this point we have a concession. You can't think of two inferences. Right? Am I misstating that?
Well, I don't think that we're conceding because I think that
what
there's
if-
something that's an impermissible stacking of inferences.
Okay, hold on. Well, that would mean you think you want us to tipsy coachman it, right? You think that there's another reason summary judgment was proper. But the reason this trial judge gave was stacking of inferences. So it seems like at this point you're conceding that conclusion was wrong. There was not a stacking of inferences. And unless again, if you have two, give them to me. But so at this point, I'm taking your concession. There's no two inferences because you haven't been able to give them to us. So that was the basis the trial judge gave. You've conceded it appears that was wrong. So now what you're telling me is not that the trial judge was right, but that you think the summary judgment should be granted for some other reason.
I suppose, and basically, I think the trial court found that based on the video plus all of the deposition testimony, that's where the inferences came from. The deposition testimony of Wawa's assistant manager, where she talks about how they do have a policy in place where the employees go out and clean up the area, inspect the area, make sure that everything is clean, and that they have these tasks to perform.
How does that stop somebody from looking at the video? And again, this is just one inference, inferring it was there the whole time, and that was a length of 20 minutes.
How does that stop somebody from?
Like the evidence that you're pointing to, the depositions, and I agree there was other evidence. But bottom line, how does that stop a jury from looking at the video and inferring at least one inference, even if you don't think it's direct inference, that oatmeal was there for 20 minutes? I'm looking at the video. I don't see anybody drop it. We know it's there at the end. The video is 20 minutes long before she slips. Therefore, it was there 20 minutes. We've got this 15-minute rule that all the other DCAs that have looked at it have adopted. One inference, more than 15 minutes, summary judgment denied. Where am I going wrong?
Well, I think that going back to the earlier arguments, there is no bright line rule, even though the other DCAs have found that 15 minutes might allow for a trier of fact to decide that there is no bright line rule. The statute doesn't say that. The case law thinks that, they've decided, like Your Honor said, out of thin air, they came up with this 15-minute rule. And so because of that, I don't think that necessarily demands that this go to.
The rule for you, do we need to certify conflict of those DCAs?
I mean, honestly, I don't think that there is enough evidence here. All we have is the video. All we have is that 20 minutes. All the plaintiff has is the 20 minutes. It's the plaintiff's burden under the statute to prove that the business establishment has constructive knowledge.
Correct, counsel, but you're allowed the one inference. You agree with that, right? Are you, and they don't have to have all the evidence. There can be conflicting evidence. They just have to have some, because remember, it goes to the jury. They're entitled to ignore one side's evidence and adopt the others, right? So they don't have to have overwhelming evidence. They just have to have some evidence. Are you telling me a jury couldn't look at that video and say, I see the oatmeal there? That's not an inference. The oatmeal's there at the 20-minute mark because she slips on it. Somebody cleans it up. That's not an inference. That's direct. It's on video. We have it. It's a fact. And nobody disputed it. And nobody drops it. We don't see anybody drop it. That's a fact that we don't see anybody drop it. Is it not at least a permissible inference that a jury could make that it was there, that it was therefore there at the beginning of the video?
I think it is a permissible inference, but as your honors have pointed out, and as you know, we would
If it's a permissible inference that it was there 20 minutes, at least unless we certify conflict with that 15-minute rule, how do we not reverse this case?
Well, again, I think that there just isn't enough evidence. The plaintiff only testified in her deposition that she slipped and fell on something that she didn't see beforehand, and she didn't know how long it was there or who put it there, and gave no other evidence, no other testimony regarding whether, as your honor indicated, like that it was dried up or that it was there for a long time. And then
Counsel, is it in your mind, is the question before us just whether 20 minutes is enough or whatever, 19, whatever is enough time? And that's like the question before us, and whether this is a bright line rule? That's not what I got from the answer brief.
I don't think that's the only issue here. Because there is no other evidence, that's what the plaintiff would like this court to believe, is that the video is almost 20 minutes, and this court should find that it should go to a trier of fact. But what we're arguing is that there is a lack of other evidence, a lack of any evidence other than the video to
But why do
show.
you need more than the video, counsel? You just need evidence from what to create a dispute of fact. You don't have to win the dispute. The jury decides the dispute. So you have your evidence and they have their evidence. You just said a permissible inference from that video was that it was there for 20 minutes. We've got a 15-minute rule saying that creates a dispute of fact on constructive notice. Why is it a legitimate argument to us to say, even though they had some evidence, it wasn't enough evidence? Isn't that the opposite of how summary judgment works?
Well, I don't think that there's no dispute here about any of the facts. And so,
Are you disputing when the oatmeal fell on the floor?
Your Honor indicated earlier, we don't know when the oatmeal fell on the floor. It could have fallen 1 second before the video started. It could have been longer than that. Or it also, as Your Honor hypothesized earlier, that somebody could have tossed it out of the window on one of the cars that we can't see on the video. So there's any number of things that could happen, even though the spot on the video where she falls is clear, you could see her fall. You can't actually see a substance on the ground.
And counsel, that's a reason to infer that it wasn't there. But you've already conceded a different permissible inference was that it was.
Well, I can't concede that it wasn't there because somebody cleaned it up. So there's no
Yeah.
way I can't.
No, but I mean, at the
I'm just
beginning of the
saying-
video, right? You told me that you're arguing now that we don't know how long it was there,
Correct.
right? We didn't see somebody slip, somebody else walked over the area. And that could lead to a permissible inference that it wasn't there at the beginning of the video, at least, right? But you've also conceded that a permissible inference was that it was there at the beginning of the video. So we've got a permissible inference that a jury was entitled to make that it was there for 20 minutes. Okay, you've conceded that. And we've got case law from at least 3 or 4 DCAs saying 15 minutes is enough to create a dispute of fact on constructive notice. Why does that not mean summary judgment should have been denied?
Again, I would rely on the trial court's findings in the video showing that all of these other pedestrians walked through the area without incident. Nobody stopped to look at it. Nobody stopped to look at their shoes. The vehicles drove through the area without tracking it anywhere. There's no other evidence that it was dried up or old or anything like that. And so, I think that with looking at everything all together, plus the assistant manager's testimony that They do use an ordinary standard of care by having the employees go through a series of tasks, twice per shift.
Does any of that mean that the only permissible inference was that it was not there for the full 20 minutes?
I suppose so. We don't see anything in the video that anybody tosses it out or drops it, but I guess it could be something that happened because, and obviously if we don't, we couldn't see it. If a car, someone in a car did it. But my point was earlier that you actually can't see the substance on the ground. And so it was such a small amount, whatever it was, like it wasn't a pound of oatmeal on the ground, and so because you can't actually see it in the video, we don't know when it was actually dropped, but I can't say that it wasn't there because obviously somebody
Right.
cleaned it up.
Right, so it's one, I guess when I say wasn't there, I want to could be clear on the time, wasn't there at the beginning of the video, the 20 minutes before she fell. You can't tell us it wasn't there. And you
Correct.
agree, at least one permissible inference was that from the video, was that it was there at the beginning of the video, correct?
Correct.
With regard to these plus factors, all the cases, you point out that they didn't have any plus factors here and they don't. All the cases that concerned plus factors, involve cases where the plus factors helped indicate the length of time the substance was there when the length wasn't otherwise known, right? So, you have skid marks through a puddle of, laundry detergent in a supermarket. The skid marks tell you somebody probably just didn't spill it because people had time to walk through it and make skid marks. If you have 6 different sets of footprints, that tells you at least 6 people walked through there. All the plus factor cases I saw seemed to be cases where they were looking for indications of the time, and they used the plus factors as a way to create a jury issue on how long it was there. Here, they're not relying on the plus factors because we have a video. So I was a little confused by the need for plus factors. Am I not wrong? Am I not right that in the plus factors were used in the case law, not as some kind of independent floating evidence of negligence, but as evidence from which a jury could determine that it was there at least 15 minutes, right? Am I right how plus factors are used in the case law?
I agree with you.
So does it make sense to say they need plus factors in a case where they're relying on video evidence rather than plus factors to prove the length of time?
I think that yes, we still need to look at them. We cited to the Pallavicini case where there also was a video, but they and
But
some,
in that case, the video didn't show this. The video didn't show the location of the substance, right? Here we have a video of the location that runs 20 minutes, and so the plus factors used. The video there didn't tell us how long the substance had been there, and so in Pallavicini they did exactly what I'm talking about. They used plus factors as evidence from which a jury could determine that it had been there a sufficient amount of time to give constructive notice. Here, they're not claiming to prove their case through plus factors. They're claiming we have a video. And it's not like Pallavicini. We see the spot where she fell in the video where the liquid supposedly is. So that's what I'm saying. In a case where they're not relying on plus factors, where they're just saying, we know that we don't need plus factors to establish the time because we have a video. Does it make sense to insist they have plus factors?
I do believe so. I mean, the cases all talk about it. I mean, just like, the cases talk about this 15-minute rule, the cases talk about the plus factors. I think that we need to look at everything in total.
Let me ask you this. If they say you could see the oatmeal in the video, okay, say it was just big enough to see it, and say no car drove by and nobody else walked over it. So the oatmeal is pristine. There's no footsteps in it. And we have a direct line of sight on it, and we know you can see it visible in the video for the whole 20 minutes. Would you still be arguing they need plus factors to show how long it was there?
No, Your Honor. Obviously, if it was there at the beginning of the video, then, the only thing that we wouldn't know is how much longer before the video it actually, when it was put there.
Right. So you agree the plus factors go to the length of time. They're evidence from which you infer that it was there a certain amount of time.
I would agree with that.
So why are plus factors relevant in a case where they're relying on a video instead of plus factors?
I think that the video here, although it's a clear view of the station as a whole, I don't think that area, is as clear as obviously we've all been discussing all these different things that could have happened. where somebody dropped it or somebody.
Correct, but you've conceded one permissible inference of the video, is that it was in fact there the whole 20 minutes.
The parties below had agreed that it was there. I don't know that they necessarily agreed that it was there for the entire 20 minutes, but because we can't tell whether or not somebody dropped it and it's not seen in the video, their back is to the video or,
Correct,
Or-
but you agreed previously that that is one permissible inference of the video,
yeah,
that it was in fact there.
yes.
Without any plus factors, somebody could look at that video and infer that was there 19 minutes and 54 seconds, correct?
Yes. But
My
the,
understanding of your argument in the answer brief, counsel, was that that was not a permissible inference because that would be based on speculation. Was that not what the answer brief was trying to tell me?
we did discuss the speculation issue. But again, it's just a matter of how much longer other than the video, earlier than the video that it could have been placed there. But, it could have been put there by somebody else and you can't see it in the video. It just doesn't, it doesn't seem as likely that where people were walking, and that would happen. But no, I mean, the oatmeal was there. That's not an issue.
The fact that the oatmeal was there after 20 minutes is not what I'm talking about. My understanding was that your argument and the answer brief was that it was based on speculation, that it was there before the video. And if it is based on speculation, that then a permissible inference is not that it was there for the 20 minutes. That would be an impermissible inference because it would be based on speculation. But you're telling me, I mean, that's what you've stated here today, I think, is that this is a permissible inference, which in my mind would mean it's not speculation. Then I feel like I'm not understanding what the new argument is, if you agree it's new.
I don't think it's new, Your Honor. I mean, basically, the parties agreed that there was oatmeal there. I don't know that there was necessarily a discussion that it was there prior to the video starting, but there's no other, I guess I'll call it direct evidence that we can see on the video that somebody in that 19 minutes and 54 seconds are the ones that actually dropped the oatmeal. And so, yes, I think that it probably was there before the video started. We just don't know how long it was there.
Now, doesn't that very much become a question for the jury? I mean, if you're saying that, and
You just
where's,
said something very key. You didn't just say that it was permissible inference. You said it was probably there at the beginning of the video, which means it's not just a permissible inference, but the best inference.
Your
Those are
Honor,
your words, counsel. You just told us it was probably there at the beginning of the video, did you not?
I think that the parties have agreed to that. I don't think that, I don't think that the defendant ever argued that it wasn't there at the beginning of the video.
I thought that the concession was that the video doesn't show anyone else dropping it. Is the concession, do we not have an issue? This is very important, I think. Do we not have an issue in this case about when the oatmeal fell? Do you agree with him that the oatmeal fell prior to the video beginning?
I don't think that the parties disagree with that. I think that was not ever really argued about the actual timing of when the oatmeal was dropped. There was never an argument. It was never discussed that
But then why would the
somebody
trial
else.
judge get into inferences? If that's just undisputed, wouldn't it then be, doesn't the statutory language tell us that if it's there for a certain amount of time and it's enough time to give rise to constructive notice, that's what the jury decides?
Well, the statute says that it has to be a sufficient enough amount of time, but it doesn't say what that amount of time is. It's the case.
Doesn't that go to the jury though?
Well, I think the trial court was focusing on the fact that all these other people and these vehicles drove through and walked through the area without incident and without tracking the oatmeal through
That
the.
makes me feel like he's not presupposing that the oatmeal's there before the video begins.
I don't think that he made that jump in the order. He never discussed
So
that.
what is the error that the trial court found? That should have us, I'm just kind of confused because your argument here today doesn't seem to line up with the answer brief. So what is it directly that the trial court got wrong in granting summary judgment?
It's not my position that the trial court was wrong on the appellee.
Okay,
So, it's our position that the trial court was correct in finding summary judgment because Ms. Oliver did not prove that Wawa had constructive knowledge that the oatmeal was on the ground.
But you just said that the oatmeal was on the ground.
I'm sorry, for sufficient enough time that the oatmeal was there, that Wawa should have come to know that it was there and have responsibility to take action to remedy it. But no, it was on the ground. It's not an issue. Obviously, they came to clean it up, so it was there.
Council, your time's expired. Do we have any further questions? Thank you, Council. All right, Mr. Shanine, we gave your opposing counsel 2 extra minutes, so I'll give you 2 extra minutes as well.
Thank you, Your Honor.
Mr. Shanine, if we do not wish to adopt the 15-minute rule, either because we just disagree with it wholesale or because we don't think it should be extended outdoors, how would you propose we write an opinion reversing?
Certainly, Your Honor. And let me be clear, you do not need to adopt the 15-minute rule in order to reverse the trial court's decision. Instead, it would be really it could be a very simple decision that discusses what the standard are for summary judgment. And I think it's important that we have some enunciations specifically by the 6th, because we need more case law for us to use when we're practicing on exactly this subject.
And slip and falls?
Well, it doesn't need to be slip and falls, just generically on summary judgment, but yes, on slip and falls too, frankly, on anything.
All right, how do we write this opinion?
This
Counsel?
opinion would be that this is the standard. Here's the statute. Here's the standard for summary judgment. Summary judgment with the new changes requires this. That does not mean that you have to, rebut every possible thing. You are allowed one reasonable inference. Here, the plaintiff presented video evidence that the parties conceded oral argument creates one reasonable inference. Therefore,
well, the reasonable inference
court,
he conceded was that it was there 20 minutes.
That's correct, Your Honor.
Yep. All right. I know if we don't just want to not adopt a 15-minute rule, but
Right.
don't want to adopt a 20-minute rule, I think you would concede. The only thing you've proven with
Right.
all the inferences in your favor is that it was there 20
Or at
minutes
least 20 minutes.
outdoors.
That is correct, Your Honor.
Without adopting a 20-minute rule,
Right.
how do we write this opinion?
That the amount of time, so long as it is a reasonable amount of time, should be a question for decision by the jury, and it should. That
So
it-
any amount of time, not
Well,
five, whether it's
and-
30 seconds or 5 hours?
Well, and we can envision scenarios in our mind where 30 seconds might actually be enough. We can envision other scenarios where an hour would be not enough. So to be honest, I'm with you, Your Honor. I think that to choose the 15-minute number is somewhat arbitrary, but is a general common sense feature that 15 minutes is a reasonable amount of time for anyone to have discovered something, as long as it's inside their building or in the direct curtilage to that.
But- Okay, I just told you we don't want a 15-minute.
Well, and
It seems like the alternative you're giving me is just say there's no rule and that this is always a jury question.
I would be comfortable with that, Your Honor.
Think about your burden.
Yeah, so counsel, what if I think you have a burden? I appreciate
if
the
you-
candor.
Okay,
What if I think you have a burden to establish the ordinary standard, what is the exercise of ordinary care?
well, and
And where, and what, and where would I look to in the record here to say they established the standard of care?
and again, this is where the province of the jury must be paramount, that the jury,
But you've got to give them something.
I agree, Your Honor,
So
and
where was you, what evidence in this record
Right.
did you have pointed a jury to say, this is the standard of care for how often you should inspect the outdoor area of a gas station?
and I do believe that is something that the jury does not need an expert on. The jury can use its common sense, but
Okay,
it
but
could-
what record in this, and what evidence in this record
We-
did they
we-
apply their common sense to?
we also have the direct admission from Wawa that, yes, we agree it's important for us to inspect this area. And yes, we send an employee. They only send their employee on much longer spans.
Counsel, I'm
And
going to ask for the third time.
Okay.
What evidence in this record would you have told the jury, here is our evidence as to the appropriate standard of care?
And to answer that question directly, it is because both parties were relying upon the then existing 15-minute rule that no one believed it was necessary to give an additional standard of care. Given the direction of this court on remand, the parties would most certainly be advised that they need to prepare that type of evidence because a directed verdict under the enunciation by this court would be in order if that type of evidence is not there. But summary judgment, when that standard didn't exist to the knowledge of any party, would be inappropriate.
But counsel, you're saying that everyone in this case was going with that bright line rule.
That's
That
correct.
can't be true, right? Because Wawa didn't concede at the trial level that was enough time, right? They're fighting for summary judgment on that point. Why would they file a motion for summary judgment if they were going to concede A, that the oatmeal was definitely there before the video commences, and B, that in the state of Florida, we've got a bright line 15-minute rule? Why file a motion for summary judgment?
Your Honor, we believe that this was actually not an appropriate case for summary judgment resolution.
I know that, but what
Oh.
you're saying, Mr. Shanine,
Right.
is they were all going with the idea that it
Right.
was 15 minutes, a bright line rule. We don't need the standard of care. And I think if we write this opinion the way that
Sure.
you want us to write it,
Right.
that Wawa's testimony about when they send their workers around to inspect, which I think is like at 6:30 a.m., right? So it was before this video.
Right.
They're going to have to redo all of that, right? Based on what we say, if we just adopt that.
For the health, safety, and welfare of the customers, I hope that they do so, Your Honor. But the answer is, Your Honor, that the summary judgment was inappropriate because there was a question of fact for resolution by the jury. What the contours of the standards of care are not clearly defined, and I think it would be hard in this opinion to define them.
Are you saying that issue is not before us?
I am, Your Honor. Thank you.
Any
With that,
other questions?
we respectfully request this court to reverse and remand to allow this case to proceed forward based upon the evidence available.
All right, thank you, counsel.
Thank
Thank you, everyone. We'll be in recess.